Hi everyone, it's Attorney Knighton of Sterling Law Offices, and today I'm talking about how debt is divided in divorce. In Wisconsin, we are governed by statute, how we divide property. And debts are on the other side of assets that must be dealt with in divorce. So we would have to talk about both assets and equal division of debts. If you can't agree on how you're going to divide up debts, then the court generally considers several factors when it's going to divide debts. First, who made the original debt? Why was a debt entered into? Who was benefited? Was both husband and wife benefited by the debt? And who's also going to get the asset that is connected with the debt? So is it a mortgage attached to a home, and who's going to keep the house? Also, who's able to better pay for the debt? It's also good to know that just because you agree to pay a certain debt or the court awards a debt to someone, if it's jointly titled in both parties' names, either party can be sued if one party misses a payment, because the courts cannot change any contracts that were entered into, including debts. So if you both signed up for that joint credit card, you're both responsible. If you both signed up for a mortgage, you guys are both responsible for that debt. If you have joint credit cards, again, both of you could be liable if one party misses a payment. The only way to really protect yourself from this is to cancel the credit card, so no further charges can be done, and if possible, refinance that credit card. Sometimes parties are in disagreement about when to close a credit card because someone wants that open credit to be used, also just wants to keep their credit score open by having that card open. So you'll need to get a court order if there's a disagreement about whether or not to close a credit card. And if that does happen, you're going to need to notify the credit card company that you're closing it. You can do that by certified mail and have a return receipt with a letter saying that you wish to close the account. If at any time you have too high of a debt load and you're considering a bankruptcy, you need to let your divorce attorney know right away. The bankruptcy causes what is called a stay, meaning a hold open of your divorce proceedings, because in divorce court they have to divide all assets and debts during the divorce process before you can be adjudicated divorced. And so the court will wait to find out what's going to happen to the debts in bankruptcy court. So remember, just as far as there has to be a division of property in a divorce, there also has to be a division of debt. Make sure you understand all what the debts are and have an idea of how you want to divide them. And remember, joint debts are still jointly the responsibility of both parties. So if one party misses a debt, the other creditor can and will come after the other party to get payment. Now, there can be things done in your marital settlement agreement that an attorney can draft to protect you from that creditor, and that you can eventually go back to courts and collect from your spouse if you end up paying the outstanding bill. If you have more questions, we have a blog and plenty of tools on our website. Check us out at www.sternlawyers.com. See you next time.